go ahead and call this meeting to order.
Hold the mic.
Thank you. Okay. We're going to go ahead and call this meeting to order. Please call the roll. Oh, I'll get it for you.
Oh. This is the meeting of the Complaint Committee for November 22nd, 2016. It is 5:30 p.m. On the call of the roll. Member Baranetsky. Baranetsky absent. Member Hinsey.
Present.
Hinsey present. Chair Tesfa.
Present.
Tesfa present. We have a quorum. I do not know of any agenda changes at this time. However, I just would like to announce this was not published on the agenda, but it is the intention of the chair to go no longer than 7:30 today. Any items not covered by 7:30 will be continued to a future meeting. Item number 2, approval of the September 27, 2016 Complaint Committee meeting minutes.
Do we have a motion?
So moved to approve the minutes.
Seconded by myself. Do we have any public comment? Thank you.
Hi, Peter Warfield, Executive Director of Library Users Association. I wish that some of these things were a little more specific as to what exactly is intended or being done. And it's not clear to me, for example, where it says Member Wolf, seconded by Member Moss, moved to send a summary of the committee's discussions and recommendations regard the complaint procedures to the Rules Committee for consideration. So I imagine that's a separate document, but it's not clear whether that's the minutes or whether that's a separate document and where one might look for that. In general, I just want to say that the issues of complaint procedures have been going on for a very long time, more than a year. And I have repeatedly come to meetings where these things were put at the end of the agenda and then not taken up over and over and over again prior to the present chairs coming onto the task force in spring, early summer. And it's very distressing because the rules, when they have been frequently changed in midstream at meetings, literally at the time of a hearing starting, things like combining complaints when somebody has worked hard to prepare. There's a whole range of issues that are very significant. And the agendas repeatedly talk about generalities of change when in fact there's only a portion being considered or only certain conditions being considered. And again, what your page layout looks like is a lot less of concern than whether, for example, as in past versions, you allow the administrator to knock out complaints. That's very, very serious. That's basically letting the administrator, and previous versions had that your administrator could, under certain circumstances that he or she alone would decide, could basically reject complaints. And that's not in the law. So the whole question of procedure, of usurpation of justice, repeat complaints. If an agency is a repeat violator, then maybe there's repeat complaints. That's a very sensitive issue. And I suffered from Library Users Association having a year-long delay in hearings that came up in your time here very recently because it was just decided in a very arbitrary manner. So I think these things are very important. They also need to be noticed, and they also be noticed more specifically. Thank you.
Do we have any other public comment?
On the minutes only.
No, thank you.
On the motion to adopt the minutes, Baranetsky absent. Member Hinsey.
I wasn't there, but aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. Next on the agenda is item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Hi. I have several issues. First off, if the meeting is going to be 2 hours, I request that uniform time limits be spent on each complaint, because I have a number of complaints, and my concern is I'll be sitting here and won't get finished. And that's hard, because when you reviewed it and you have everything in your mind and you're ready to go, and then suddenly, so there's that. And then there's the issue of, I know at this committee level, there can only be a recommendation made, but my concern is when you have the repeat violators, the repeat department, doing the same thing over and over again, and even though they're found in violation, if there's no referral back to a subcommittee for basically the same thing over and over again, it just gives them pause to continue doing the same thing over and over again. For example, this morning at 10:30, I went to an Arts Commission meeting. I don't go to those meetings very often because I know they're going to be very messy. But this concerned a colleague, a street artist, and they have very stringent rules, and this guy's like a major violator. And I wanted to go and, say my piece and what was going on. And that meeting was run so badly. It was frightful, actually. I was verbally abused by Howard Lazar. There were no supporting documents for me to view as a member of the public. The agenda was not available to view. When I asked, could I see the papers that you're referring to, he threw them on the floor. So it's just the same thing over and over again, and I haven't given up, but many people have. They feel that there's no reason to waste their time at these meetings because nothing changes. And I walked out frustrated, and it's not likely that I would go back again. Thank you.
Ray Hartz, Director, San Francisco Open Government. Just a suggestion. Last Monday, I had cases before the Compliance and Amendments Committee, and it was noticed that at that time that the procedure, which had been literally in place for years of 5 minutes and 5 minutes, was now to 3 minutes and 3 minutes. And I was given the option of taking 5 minutes, but I would suggest that at least for the next few months, there be a rather large indication on the front of any of the hearing notices where when you tell people that there's a hearing, to make them aware of the fact that this change has been taken, so that people don't show up prepared like I usually do to use the full 5 minutes and then kind of get taken aback when it's only 3, because that really throws you off, especially when you have to readjust everything at the last minute.
Hi, Peter Warfield again, Executive Director of Library Users Association. I'd certainly like to agree with the previous 2 speakers with respect to what they said. The first one, bottom line, concern that nothing changes with respect to, anyway, what the practices are of an agency, and Mr. Hart's talking about changes to rules being better noticed. I have a couple of concerns about procedural shifts, which I think are very hard on complainants, and I think changes should be very carefully and lengthily, if you like, considered with a lot of public awareness and input. So the first concern that I've got is the timeliness of your verdicts, if you like. The statute says the task force is supposed to render a decision to the complainant, at least in certain cases, within 45 days of the complaint being filed. And I don't see at any time, including at the complaint procedure discussions that I've been present at, that there's any attention being paid to the statutory requirement. You're supposed to present a document to somebody 45 days after they have filed a complaint, and I think you need to, among other things, gauge your procedures in accordance with that timeline. That also goes to toughness, if you like, of your attitude toward the law and toward agencies. I think that when you're not clear and tough on abiding by the law, you only encourage violations. The agencies already are, I think, pretty blasé about violations. They don't like to come here because they don't control the meeting. They have to answer for things, but what's the worst that can happen? A slap on the wrist, a violation, and there's no penalty. There's whatever publicity, perhaps, that somebody can drum up. And that also gets to repeat violators. When you have repeat violators, whether it's on the same portion of the law or whether it's the same agency repeatedly violating the law, I think you seriously need to consider upping the ante on them. So, for example, if they don't seem to be interested in following the law, they need to have something tougher, like next time it's going to be a willful violation. You need to get clear on the rules and follow them. And that's something I think you can do. And that's something that I think has more serious consequences. I think it would also be helpful if you would have clarity on your interpretations of certain portions of the law so that people can find out before they actually file an actual complaint. Thanks.
Thank you.
There it is.
Seeing no more public comment, can we move to item number 4?
Next on the agenda is item number 4, file number 16077, complaint filed by the Library Users Association against City Librarian Luis Herrera and the Public Library for allegedly violating Administrative Code, Section 67.21, 67.25, 67.26, and 67.27 by failing to respond to an immediate disclosure request in a complete manner, keeping withholding of records to a minimum, and failing to provide justification for withholding.
And before we get started, I just want to note that Member Baranetsky is present and will be working with Member Hinsey and I for the rest of the evening, or till 7:30.
Jurisdiction.
Do we have a motion to find jurisdiction?
So moved.
Do we have a second?
Second.
Thank you. Do we have any public comment on jurisdiction? Seeing none, can
May we adopt that without objection?
that'd be great. Thanks.
That motion to find jurisdiction is adopted without objection.
Can we hear from the complainant? And Victor, before we get started, can you remind everyone in the room about how much time we'll be giving to speakers this evening so that we can be respectful of everyone's time, get everyone out of here in a timely manner, as well as have as many cases heard as possible before 7:30?
Yes, listed on our agenda, the complainant may present his or her facts and evidence. They are allowed up to 3 minutes. The city may present their facts or evidence. They are allowed up to 3 minutes. The matter will be with the committee for discussion at that time. At the end of that discussion, the parties will be allowed up to 3 minutes each for rebuttals. Then the matter is with the committee for possible motions, and after that there would be public comment and then a vote on the motion.
Great.
Thank you, Victor.
And I presume that the committee can ask questions if they wish.
The committee can ask questions, and as a reminder, here we're trying to really focus on, a few facts of the case, figuring out what the specific issues of the complaint is. You'll be able to have your full hearing before the full task force, so that you have the opportunity to be heard by, all of our members. But right now, we're trying to really get everything organized, and we're using this as an opportunity for a pre-hearing conference type situation. So thank you. And if you could just stay focused on those issues, will be the best use of your time. Thank you, Mr. Warfield.
Okay, so I'm Peter Warfield, Executive Director of Library Users Association. We brought this complaint August 22nd, 2016. Basically, I initially thought I would just come here and answer any questions you might have, because I think that the case is pretty clear. We asked for 3 weeks before the American Library Association having its huge convention with 25,000 people coming to the city and using both the regular Moscone and the North Moscone and the annex to Moscone on the other side of, I think, 4th Street or 5th Street. We wanted to know what the San Francisco Public Library participation would be in that convention or conference. And we have on your page 17, our page 2 of 5, our immediate disclosure request. We wanted to know what the library was participating in with respect to ALA annual conference later this month, limited to the following. And I always try and limit anything so that it makes sense and it isn't overwhelming for either party. Staffers who are presenting or participating in presenting a program talk and the like, so I wasn't looking for who has signed up, who's attending, and so on. Library-provided events were specifically for ALA conference goers, and library facilities to be used for conference events, including time, location, event. We got a response, which is included in the complaint, and the response was, we sent this to the head of the library, Luis Herrera, with a copy to Sue Blackman, the Library Commission Secretary, who's under his control and has been assigned to answer most requests, if not all. So we got back 2 programs forwarded from the Deputy City Librarian, Michael Lambert. And he says, the ones I know of are as follows: Luis Herrera, relationship building, and so on and so forth. That one you can see on your page 19, my page 4 of 5. That one was happening Thursday, June 25th. And then another one where the deputy and Karen Strauss, who at the time was, I believe, chief of the Maine, was also going to, those 2 were presenting something, and on our page 505, your page 20, that was also on Thursday. Now, we have a history with Mr. Lambert that precedes your presence here, and that is in January, a year and a half, almost 2 years ago, we asked for some very key document, and Mr. Lambert did what he acknowledged was a cursory request to where he was looking and who he asked, and he said he didn't think it existed. That was a violation. He didn't do a really serious job. And I believe that's exactly what's happened here. I know that the library participated in more, and senior staff, more than just what they gave me. Thank you.
Do we have any other speakers on behalf of complainant?
Hi, Ray Hartz, Director, San Francisco Open Government. I normally wait until both the complainant and the respondent have spoken so that I can address any issue that either might have raised. But since the respondent is not here, I will mention it. Basically, the request Mr. Warfield made of the library was to the president of the city librarian, and it was a request saying who on the staff is going to be presenting at the ALA conference. And one of the things that he failed to, Mr. Lambert in his answer failed to reveal, it was Mr. Herrera. So it's kind of like, okay, Mr. Herrera, you must know what you're going to be participating in. How is it that you could give an answer or have someone give an answer which doesn't even completely cover your presentations, let alone perhaps missing other things? So I think Mr. Warfield's case is very accurate. He wanted to know all of the things that the library was going to be participating in at the American Library Association conference. A countrywide conference, and was told a couple of the things, and other things that they were participating in he was not told about.
Thank you. Do we have anyone to speak on behalf of the respondent? Does not appear so. With that, I would like to bring this before our members. Do you have any questions for the complainant? I do, if the complainant could come forward for a few questions. Thank you, Mr. Warfield.
Yes.
So just looking over, cursory look at your complaint, it looks like you were looking for a couple of items, but the main one that did not receive a response was the document that would be listing what staff would be participating and presenting at the conference. Is that correct?
Well, I didn't know what documents specifically they would have in regard to staff participation, but I certainly would expect any number of possible responses as to who is participating and in what way. This one is on a panel that's discussing this and so on. And I actually might have gotten additional material, and if they had been really thorough, I might have gotten emails back and forth with ALA about organizing it and so on and so forth. But my main purpose, as it's stated here, is I wanted to know who from the library is going to be participating in or presenting a program or talk.
And is all that you received what you showed us on page 19, which was the email that had the two talks, one by Luis Herrera and then the second one that was with Michael Lambert and Karen Strauss?
Thank you, Madam Attorney, for asking. The other piece that I got was times and events that were happening at the library, which is what I asked in part. If you look on your page 17, our page 2, library provided events for specifically for ALA conference goers and library facilities. So that was a second part where they said we're having a party for, I don't know, foreign libraries at the main library, and we're having a such and such in this conference room at our library. So they for that, they could have gone to their scheduler of spaces at the library. I think they provided, for example, a bus tour of the branches. So they said on a certain day, and we're going to have two buses going in opposite directions in a circular sort of branch navigation. So I didn't include that because I felt like that seemed like an adequate answer, but so I didn't include that. I think I tried to mention that as not included, but also not at issue.
Are there any other questions?
Yeah, I would like to just,
Member Mullins.
how do you know that there was a document with a list of everyone who was attending?
I said in answer to the first question, I don't know that there was such a specific document, but I do know that there's a whole range of documents that come when a person specifies, I'm going to talk about this, or we're going to talk about such and so, back and forth with ALA or with other participants in a seminar. I hesitate. I don't want to evade the answer, but the first thing I want to say is the library has not contended that I'm wrong. Nowhere in their answer did they say we gave a complete answer and there's nothing else that we have related to an event. In fact, I discovered after the conference at least one presentation that Luis Herrera was a part of. And it was in the printed book, which I eventually got my hands on a copy of. It was like 350 pages thick, like a phone book. And lo and behold, I discovered Luis Herrera was one of the speakers at a particular, I can project this if you want, or I can read it to you if you like. But so it was in the program descriptions section of this huge book. And I was shocked because transforming neighborhoods one library at a time, the San Francisco experience, it wasn't just Luis Herrera, it was Jewel Gomez, a former Library Commission president, Charles Higueras, a former Library Commission president, Mindy Linetsky, a former library employee and a Department of Public Works who worked for years, all of this about the bond program, which was a measure passed in 2000 to basically renovate almost all of the branches or build them new. And this was their basically gigantic story of how this 16-year process had worked. I can read it to you if you like.
That's fine. Thank you.
Question. So, to clarify, so are you actually looking for the content of these speakers' talks, or are you looking for just the fact that they spoke at a particular session?
Well, my request said I wanted to inspect at your office and receive via email information about SF Public Library's participation with respect to the ALA annual conference later this month, limited to the following. So what they sent me was okay as far as it went. Could have been more, but what's on our page 4 and 5, your page 19 and 20, was basically from the deputy city librarian, the name of who participated in which program and a description of the program, which he didn't say where he got it. Maybe the library wrote it. It looks like it's what was described in the Great Big Conference book. So either way, that seemed to me an adequate response. Who and what?
Okay.
So if you look on page 4 of 5 and 5 of 5, your 19 and 20, you'll see two descriptions with names of who from the library is participating, and they're senior people. Does that answer your question?
Okay.
I mean, I think a thorough job might have been all the memos related. I mean, this year I actually asked for something basically the same, and I got a whole load of emails back and forth with this staffer presenting this. There was actually stuff that wasn't even in the book where there were people on the staff helping to support certain programs. So I got all kinds of emails back and forth between people, and they evidently polled people who were actively participating in the conference and provided me with a whole lot more detail than what they provided here. So they could have provided all that as well, which I assume exists, but I haven't seen it.
Basically, you think that they could have done a more thorough job on responding to your request.
Well, I would call it an adequate job, a minimally adequate job. This was, the one that I'm describing was a major presentation. It was the capstone of their 16-year project. They had all these senior people presenting with the city librarian, Luis Herrera, and they just didn't tell me about it.
Thank you.
I might add also in terms of willfulness that this is a program that Library Users Association and others had over many years many criticisms and efforts at improvement, some of which were successful. So this is a long history with a lot of incidents and something that we, of course, would be very interested in seeing. How do they describe it to other librarians, general public?
Thank you, Mr. Warfield. If we don't have any more questions, I'd like to bring this to the committee for discussion, and then we can make a motion.
I believe, yes, you can discuss it, but I believe we would need to take rebuttals
Okay.
and then make a motion.
Okay.
Okay.
Member Baranetsky, I think it's the question that you ask is very interesting. The one, it appears that there's information out there about employees participating in different capacities at the ALA conference, but at the same time, we don't know if this was aggregated into a document or a list that was in the possession of the library. If it was a document that was in their possession, might have been a document that was in the possession of the ALA conference coordinators. We don't know. But that being said, it might be interesting to hear more from the respondent as we require them to appear. Do you guys have anything else to say before we hear rebuttals?
No, I mean, I agree. I think that's the difficulty in understanding what were the actual records at hand. I think it is interesting that there was an event cited to that was not provided for in any of the documentation, or that was not discussed in any of the provided for documentation. But without knowing more, it's difficult to make a further decision.
Yeah. I think the question here is this a document that, if it does exist, is it a document that the library possesses, or like you said, is it a document that's more likely to be in the purview of the conference organizers?
Yeah. At this time, can we hear a rebuttal from the complainant? Oh, the respondent isn't here, so can we hear a rebuttal from the complainant?
Peter Warfield, Executive Director of Library Users Association. I think you need to look very closely at Section 67.21. I don't think that the possession of the record makes it unavailable to be provided if it lives physically in another place. You had a case with Ray Hartz where the library said, go fish with the police commission. And eventually this body decided that was inappropriate. The library had records with the police commission, as I recall, that they had access to. So,
I mean, if it's duplicative, that's one thing. But if it's entirely within the hands of another agency, that's another.
Then that's no longer a public record in the city.
I'm not hearing.
Either way, we'll just allow Mr. Warfield to have his time to speak. We don't
Well,
have to respond.
I'm always very happy at questions, and I appreciate them. If somebody has a charge account, well, I don't know that I should give examples. I don't know about duplicative. Let's put it this way. There's no way the library can organize a presentation without correspondence back and forth, coordination efforts between the library and the ALA, coordination efforts amongst the participants, who here included Luis Herrera himself, plus 1, 2, 3 other people. There would have to have been communication between them. And again, I don't think that whether or not the library's computer contained a document, if they're making a presentation in 3 weeks' time, a major presentation at ALA, it isn't up to them to tell me you can go fish in documents that the ALA has. It's up to them, as they did on page 4 of 5 and 5 of 5, to provide basically reasonably responsive information. And I do think this is an issue that if you really believe the fact that the ALA maybe had all of their stuff, I think that's very wrong. Let me go back to a prior case that we had regarding a what do you call a recorded meeting that's both visual and oral? A webinar. We had a case about a webinar. The deputy city librarian asserted that a certain webinar showed that a concern we had and had written about in the press was not really, that he had attended it and that he had clarified, it had been clarified there. When he did not give us a copy of that webinar, this body found him in violation, even though the webinar was living, if you like, on the vendor's website, readily accessible to the customer, which is the library. So I hesitate to, want to go into the details of this, but basically the library had to have had and did have information about this and any other seminars, and they certainly haven't denied that they withheld stuff. They only said, well, we gave him 2 things, and then we told him to go fish in the ALA website.
Thank you.
Thanks.
Do we have a motion?
It's a new type of motion for us that we probably haven't done before. I believe it will be something in the vein of a motion to send the matter to the task force for hearing. If you have any recommendations, you can state those now. And I believe that I will be working with the chair to provide a summary of today's discussion to present to the task force at their meeting.
Yes.
Motion to refer the matter to the
Yeah,
task
I can make
Yeah,
that.
I'm trying to
Can
think
I make
if
one of
we
those
have it.
motions?
So maybe I'd like to make a motion to recommend that this file be scheduled for hearing before the task force. In that motion, I would like to be able to express to the complainant and respondent to take the concerns that the members here have raised today, so that they can create a file that it speaks directly to these issues, particularly the section of the code that refers to possession of documents, things of that nature, existence of documents, so that we can really keep our hearing focused when this is brought before us, now that you've heard our concerns.
Second. I didn't cut you off, did I? Okay.
Thank you.
And just to let you know, I will work with the chair of the full task force to schedule this either for December the 7th or for the first task force meeting in January. All parties will be notified once that is
Thank you.
established. Public comment on the motion.
Do we have any public comment? Seeing none?
On that motion, Member Barnetsky.
Aye.
Barnetsky, aye. Member Hensy.
Aye.
Hensy, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion has been adopted, and the matter will be referred to the task force for hearing.
Thank you. Can you call the next item, please?
Next on the agenda is item number 5, file number 16086, complaint filed by Library Users Association against Library Commission Secretary Sue Blackman, City Librarian Luis Herrera, Commission President Mary Wardell Guraduzzi, and the Library Commission for allegedly violating Administrative Code Section 67.7 and 67.15 by failing to post an agenda containing a meaningful description of each item of business to be transacted or discussed at the meeting, and failing to provide an opportunity for members of the public to directly address a policy body on items of interest to the public that are within the body's jurisdiction.
Yes. Do we have a motion to find jurisdiction? Do
So moved.
we have a second?
Second.
Thank you.
Is there any public comment on jurisdiction? There being no public comment, may we adopt this without objection?
Thank you. Can we hear from the complainant?
Peter Warfield, Executive Director of Library Users Association. This one, again, I think is pretty much self-explanatory if you have taken the time to read it. It's a one-page complaint, and I think it's pretty clear. And the library's response is, well, maybe we should have done it differently or better, but they cite a particular, what they seem to think is an escape clause. It's very important in Sunshine that there be notice of discussion items and action items in an agenda so the public can know if their interests and are involved. What happened here was that they had a regular agenda with a simple adjournment listed and nothing about anybody in honor. In the June of this year meeting, as I mentioned in the second paragraph, the agenda made no mention of the adjournment being in memory of or in honor of anyone. They called the item and called for public comment. Only after public comment was made did the president of the commission announce that she wanted to adjourn in honor of a retiring librarian, Tony Bernardi. This prevented the public from knowing about this in advance, from reading the agenda, or even for those who were present, like myself, being able to comment, because they did not call for public comment on that motion. Now, I write that this was obviously planned, and you may ask me why. I'd be glad to answer, but they nonetheless took the motion chair made and voted unanimously, lickety-split, to adjourn in honor of a retiring librarian. And as we write, 67.7A requires a meaningful description of each item of business and the proposed action. 67.7B defines what a meaningful description is. 67.7D, no action or discussion shall be undertaken on any item not appearing on the posted agenda. And 67.15D for dog and E for Edward talks about public testimony. Tony Bernardi had served for decades as a senior staff member of the library. She was a children's librarian. She was actually quite wonderful. And it's very unfortunate that we were not able to say some words about her retirement. And as I note at the bottom here, think about who is listed in their bylaws as preparing the agenda. It's the city attorney, the city librarian, the president of the Library Commission, and the secretary who were responsible for this. And it was a very public retirement within the library.
Thank you.
Thank you.
Do you have any speakers in favor, or speaking in favor of the complainant? None? No respondent?
There is no respondent present at this time.
Okay. At this time, I'd like to bring it for discussion among the task force members, or if you have any questions for the complainant. I have a question for the complainant, if he could come forward. Thank you.
We love questions.
I appreciate your wanting to say some nice words about this retiring librarian, but it appears that this addition to the meeting would fall under 67.7 E2, where an exception for to allow bodies to take actions of business not appearing on the posted agenda, specifically those that are relating purely to commendatory action. And I was wondering, if you think that this specific activity doesn't fall within that section, and why?
Thank you for asking. I understand that you are an attorney, and there's also another attorney present, so maybe I should ask you to read me Section 67E2.
Sure. And if you're not ready to answer, you're going to get your hearing, and this is just something that we'll want you to think about as you prepare for that time. So notwithstanding subdivision D, the policy body may take action on items of business not appearing on the posted agenda under any of the following conditions. And the specific condition we're talking about is under number 2. Upon a good faith reasonable determination by a 2/3 vote of the body, or if less than 2/3 of the members are present, a unanimous vote of those members are present that A, the need to take immediate action on the item is so imperative as to threaten serious injury to the public interest if action were deferred to a subsequent special or regular meeting, or relates to purely commendatory action, and B, that the need for such action came to the attention of the body subsequent to the agenda being posted as specified in subdivision A. So I just wanted to bring that up as a question, and if you would like, you'll also have the opportunity to formulate a response at the time of your hearing.
Well, I have a response, and I'm glad you read it. Appreciate it.
Of course.
So Section E67.7E2 is very clear. It requires a vote, which means a motion. And it requires a vote it requires that A and B, there's an and, A and B must be satisfied. So the first thing is a good faith reasonable determination by a 2/3 vote of the body, or if less than 2/3 of the members present, a unanimous vote. So that's the first thing. They didn't have a vote. But what are the conditions of the vote? They have to show, let's go to commendatory in A. Let's say it was a purely commendatory action. which I'm not sure is defined anywhere in this. It's an action. And in previous sections and elsewhere, you know that actions, as well as discussions, have to be noticed. But, and B, that the need for such action, you read this, came to the attention of the body subsequent to the agenda being posted as specified in subdivision A. So the key here is, did the issue of Tony Bernardi's retirement come to the attention of the body after the agenda was posted? And of course, the answer is absolutely no. They were well aware for several reasons, unless they were in a coma. The June agenda had a city librarian's report. And at that librarian's report, which was also not noticing Tony Bernardi, Luis Herrera mentioned it as an announcement. I have a copy of the city librarian's report that doesn't mention Tony Bernardi. So in a prior item on the same day's agenda, Luis Herrera went into a quite lengthy encomium about Tony Bernardi and her excellent service to the library and the citizens. So they at the very least knew before this item came up that she was retiring from the lips of their own city librarian. And again, it wasn't just, thank you very much for your service, it was going on at length. So if they were going to do something different and change the agenda, they could have and should have said, oh, let's later on adjourn in honor of Tony Bernardi. There are other reasons that I think they knew before the item started, and that is because when the President, Mary Wardell Giraduzzi, said it, she wanted to adjourn in honor, she said, oh, I see that Tony has left. So it seems to me clear she was keeping an eye on Tony Bernardi. I also made an information request, which I haven't brought the response to it here.
That's fine.
Tony Bernardi was a senior library manager. Tony Bernardi got an all-points bulletin about her retirement in early June from the city librarian himself. And he sent that to, among other folks, not just the entire library staff, including an announcement of a party in his office, but he sent it to the Library Commission. Now, maybe you want to get Mary Wardell Giraduzzi off the hook. Maybe she was in a coma the whole time until she woke up at adjournment. But Luis Herrera was not in a coma. Not in a coma that he couldn't send an email to everybody on the staff about this important personage's 20, I don't know how many decades of service, inviting them to a party in his own office, and sending an email to the Library Commission. So Luis Herrera certainly knew about this prior to the agenda being posted 3 days before the mid-June meeting. And so did Sue Blackman.
And thank you. But on this, it sounds like you have a lot of very concrete examples. And I think it would be really helpful, and this will be highlighted in, I hope, the motion that we get together today, that if you could bring these examples, in writing as part of your packet when your hearing is scheduled, because it sounds like that would be very helpful to specifically illustrate why this wouldn't fit under 67.7 E2A.
Once again, I think the library has been very dishonest in its argument. It didn't mention that E requires a vote, which they never took. That alone makes it a violation that doesn't fit into that section of the ordinance.
Thank you. And then
that alone. And the other thing is they have never denied, they have never claimed that They didn't know about this prior to the meeting. They did not claim that, as far as I know. They claimed they had a right under this section to suddenly surprise people. And again, even if they only just knew this moment and suddenly wanted to do a commendatory thing, why didn't they have public comment on it?
Thank you, Mr. Warfield. Do we have any other questions from the members? No. Do we have, can we have the complainant come forward for the rebuttal? I think you just sat down, but thank you. And then we can take a motion at that time.
There is, Peter Warfield
If you have anything
again.
else to add.
Yeah.
Okay.
I want to point out that I have seen, and I sadly can't point to it, I'm not sure it's within the Sunshine Ordinance. There is somewhere, I believe it's a requirement or a guideline, that if there are two stories about something, you are supposed to, in the absence of anything else, favor the complainant or the person bringing the complaint in terms of your evaluation of the facts, for example, or the truthfulness. You can see here that the library claims a section that applies, which I think it clearly doesn't apply. They didn't take a vote, and they didn't make a determination about whether it was purely commendatory, which I'm not prepared to argue right here, but I certainly would argue that this had come to their, it wasn't something that suddenly came to their attention subsequent to the agenda being posted.
Thank you.
And again, because the city librarian himself spoke, I don't know if you want me to bring a tape recording, it wasn't on the agenda as part of his report, but he spoke at length. If you want me to copy a tape and bring it, he spoke at length, 1 or 2 items or 3 items ahead of adjournment, so he clearly knew about it. Did he know about it prior to the agenda being posted? I suppose I can bring you the memo. But again, I think that's putting a very heavy burden on me. I think if the library were asked by you about the veracity of what I'm saying, I don't think they would question it or deny it either.
Thank you.
Thank you.
Do we have a motion? Or, no one is here to speak on behalf of the respondent. Can we take public comment at this time, or should we have a
Usually
motion?
it occurs after you make the motion.
Okay. Do we have a motion?
Could we make a motion for this to be brought to the attention of the committee with the discussion that was had here tonight brought into consideration? And is that
A motion to refer the matter to the task force for hearing.
Thanks. I don't know
and
the
with
specific language.
With a
yeah.
summary of today's discussion.
Thank you.
And if we could include emphasis on documentation and support for 67.7E2A.
Yeah.
I will note that we have requested the complainant to provide samples.
As well as the respondent.
Yes, and the respondent to
Not just the
address
complainant.
67.7 E.
E2.
Yeah, E2. Thank you. Do we have any, do we have a second on this motion?
Second.
Do we have any public comment on this motion? Mr. Hartz?
Yes.
Ray Hartz, Director, San Francisco Open Government. I would like to point out that the section that the Deputy City Attorney mentioned and you've been discussing, upon a good faith, reasonable determination of it by a 2/3 vote of body, and as Mr. Warfield has mentioned, they didn't do this in proper order. They basically just went ahead and did it without voting on whether, A, the need to take immediate action on the item is so imperative as to threaten serious injury to the public interest if action were deferred to a subsequent special or regular meeting. And I will tell you, I missed this meeting, and had there been on the agenda an announcement that Tony Bernardi was retiring, I would have gone just so I could have commended her for her 30-some-odd years of service to the library and to the public. And I think that it is fair to say that commending someone is not an imperative action. It's not something that would do any public harm. In fact, I think the public harm was done by not postponing it so that it could be in the agenda and any members of the public, including maybe friends of hers, could have attended and, likewise raised, stated their commendations for her. So I think, basically, I don't know what the rush for them was to do it, but if they had simply looked at the law and said, well, we don't meet both of these conditions, and since this is not imperative, let's put it on the next agenda, and that way everybody will know about it, everybody can show up, and this person will get the level of commendation that we really feel they deserve, not just from us, but from any members of the public who might want to, including Mr. Warfield, who was present but couldn't, because they'd already taken public comment. So it's kind of like Mr. Young keeping you in proper order. Say, well, you got to take motion first, then take public comment. Nobody was keeping them in order. So basically, they took public comment and then took an action based on this section of the law, which clearly they didn't meet because they didn't, number one, have an imperative need, and number two, they didn't take the vote.
Thank you. I'm seeing no more public comment. Can we call the roll?
On the motion, Member Barnetsky?
Aye.
Barnetsky, aye. Member Hinsey?
Aye.
Hinsey, aye. Chair Tesfa?
Aye.
Tesfa, aye. The motion is adopted. Next on the agenda, item number 6. File number 16085, complaint filed by Ray Hartz against Sue Blackman, City Librarian Luis Herrera, the Public Library, and the Library Commission for allegedly violating Administrative Code, Section 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Mr. Hartz.
If I could ask the indulgence for the chair, I think you might be pleased with what I have to say. There was a miscommunication between myself and the task force. The substance of this complaint is actually in the next complaint, and in the service of saving everybody time, I'd like to withdraw this complaint.
Withdraw to not be submitted at another time?
Correct.
Okay.
Because actually it is the next complaint on the agenda.
Just to
Mr.
state,
Clerk, what kind of action should we take on that?
no action is needed. The
Okay.
complainant has withdrawn the complaint, so it is no longer active, and I will note so in the file.
Thank you. If you can call the next item.
Next on the agenda, item number 7, file number 16087, complaint filed by Ray Hartz against Luis Herrera, Sue Blackman, and the Library Commission for allegedly violating Administrative Code, Sunshine Ordinance Section 67.21, by failing to respond in a timely and/or complete manner to the requests from the Sunshine Ordinance Task Force to respond to complaint number 16075.
Do we have a motion to find jurisdiction on this item?
So moved.
Second.
Do we have any comment on that motion at this time? Right. Can we take,
Would you like to adopt that without objection?
yes, please, thank you. And now can we hear from the complainant, Mr. Hartz? Thank you.
If you turn to page 79 of your packet, you're going to see the response from Sue Blackman. And basically, the second paragraph, the bottom line says, the library has searched our records and we have no responsive records to this request. I will give Ms. Blackman credit. If you look right above that, you will see a pretty good explanation of what the IDR was about. I asked for any communications between herself, members of the library staff, members of the Library Commission, who she represents, and any communications between the library at all and the Library Commission. So she's saying there are no responsive documents. But if you turn back to page 71, this is the document that I was asking for communications. So if you take Ms. Blackman's response at face value, she got this complaint from the task force, didn't tell her superior, City Librarian Luis Herrera, didn't tell the Library Commission, didn't communicate to anybody, came up with this 4-page response and sent it, and apparently, again, if you take her answer at her word, didn't get any approval from anybody or authorization to send the response. So as she is writing this response as representative of both the library and the Library Commission, I find it kind of ludicrous to think that she didn't talk to anybody, get anybody's input or authorization or anything. And I would like to have you turn to page 74, because if you look at page 74, the second full paragraph, it reads, as members of this body may be aware, Mr. Hartz has had on a vendetta against the library and its staff for years, making attacks against library personnel, and at one point during public comment at a library commission meeting, alluding rhetorically to the need for assassination of public officials. And then in the next paragraph, she writes, this is less in the nature of bona fide advocacy for open government and more in the nature of harassment of a city department that, notwithstanding Mr. Hartz's view, strives to comply with open government rules, and I have 7 orders of determination against the library to counter that claim. And then she goes on to say, we've never denied Mr. Hartz access to records or attempted to infringe his rights at any public meeting despite his berating library staff and commissioners at meetings through his aggressive tone, personal attacks, and occasional uses of profanity. And all I'm saying right here is I find it hard to believe that Ms. Blackman could put all of this personal animus in writing, defaming my character, and then claim that she did not discuss this with anybody, either the Library Commission or the library.
Do we have any other speakers on behalf of the complainant? No respondent. So at this time, do we have any questions from the task force members? Maybe if we can give us a couple of moments. Do we have any questions from the members of the committee? I have a question for Mr. Hartz, if you're available. Thank you.
Sure.
In this specific, I was wondering if you can kind of go into any details on why. I know that you have withdrawn number 6, but you said that it's encompassed in number 7.
Right.
And I was wondering if you could go into a couple of more details as to how it's encompassed. Specifically, I was looking for maybe a little bit more specificity on the response that was provided by Sue Blackman to you, and if you're looking for, specific information on what the library was supposed to provide to the task force, or if you're asking for specific information that you would like the library to provide to you on what it's provided to the task force. It just seems kind of like you're trying to submit a complaint kind of on behalf of the task force.
No.
And so that's just, if you could just give a couple of more details and clarification.
What it really comes down to is the fact that Ms. Blackman has gotten in the habit in her responses to my complaints of raising issues that I feel are demeaning to me and intended to disparage my character and my motives and things like that. She's not professional, and what she's saying is she wrote this 4-page response, supposedly on behalf of the library and the Library Commission, without talking to the library or the Library Commission, sent it, including these disparaging comments, and now claims or says with her statement that I didn't talk to anybody. And I want to know whether she is simply doing this on her own, out of personal animus for me, or whether she's being directed by either the Library Commission or the library. Now, if the library says, hey, Miss Blackman did not talk to any of us, I would say that would be kind of bizarre.
Do you think that it could be possible that she has the authority to act on her own, or do you think that she would need to have, because just in the role that she has doing this kind of work, it seems like in many cases she has the authority to act on her own.
Well, okay, so say she has the authority to act on her own. Does that include the authority to insult people in a public record? I don't think so. And whether or not she has the authority to act on her own, the Library Commission and the library are still responsible for her actions in the tone and tenor of this letter. And especially since you have to, the thing I read you where it said, despite his berating library staff and commissioners at meetings through his aggressive tone, personal attacks, and occasional use of profanity, well, she can demean me and then say, I have no authority.
But besides the personal attack, I'm kind of confused about how this pertains to Section 67.21, because
I asked to see any communications among any of these people, and her answer basically is, if you read it, I didn't communicate with anybody. I didn't tell them about this complaint. I didn't ask for their input. I didn't ask for their authorization. I didn't let them read it before I sent it. I just wrote it and sent it.
But isn't the complaint regarding 67.21 for failing to submit a response to the task force regarding that file?
No.
Okay.
If you read the actual...
Which page are you referring to?
Actually, complaint page 70. Response was not timely or complete. The complaint 16071 Ray Hartz versus the Public Library and Library Commission. In responding to the attached IDR, Ms. Blackman claims that she communicated with no one, either in the library or the Library Commission, in responding on their behalf to this complaint. And what I'm saying is, for those of you who are attorneys, if you went into court and you represented things to the court on behalf of a client to whom you had never spoken, wouldn't that cause a kind of a problem? And what I'm saying is there's a serious and continuous problem that Ms. Blackman responds to complaints, putting in these personal attacks, and then right here she's admitting, I didn't talk to anybody. I didn't talk to the librarian, my supervisor in city government. I didn't talk to these people I'm representing. I just wrote this and sent it.
But I don't understand, how is that a document that you are not receiving? Because if there is no documentation,
what I'm saying is that's something to go before the task force. Does the task force find it credible that she would do this without talking to anyone?
Okay. Any members have any other questions?
I do.
Member Baranetsky?
But there might be a distinction. I just want to clarify. There might
Sure.
be a distinction that she could have had an oral communication that would not have been put down in a written format, that would be in the possession of the agency. Just proposing the hypothetical.
Someone brought that up to me, and they said, well, that's like Mayor Willie Brown. He said that the E in email stands for evidence. And I think that in itself would be another thing. Why, with a complaint with the Sunshine Task Force, would they do everything orally? And no written communications, no. And I asked her, I said, and she said she did a thorough search. Did she send an email to the members of the Library Commission and ask them if they'd talked about it among each other? Did she send a letter, ask any information of the library staff? I just find it kind of incomprehensible that she would get a complaint against the city librarian and the Library Commission and talk to no one. And then represent in her 4-page letter, I am answering on behalf of people I didn't talk to.
Thank you. Do we have any other questions?
Madam Chair, I would just, I believe we need a clarification of the complaint title, as I believe we're talking about two different things.
I agree.
I will need to pull I believe that the library responded to this version of the complaint that we've just heard under the previous file that was just withdrawn, 16085.
Okay.
At your discretion, I'd like to pull the response from the public library and insert it into the current file. as the response in this current file that we have now is not regarding the
Yeah, that's
item.
what I'm noticing, because I'm really struggling, because Mr. Hartz is telling us it's like two ships passing in the night from the packet and what I'm hearing from Mr. Hartz. I think that his question is an interesting one. I think that the full task force will have to determine if it appears that there would be no documentation for Ms. Blackman on, how to conduct her work. If she acts on her own authority or is regularly consulting with management, it could be orally, as Member Baranetsky mentioned, but we don't know that. But it seems like the response from the library is not matching up to the complaint that we're actually hearing.
Yes, the library response in 16085 is regarding, it appears to address this issue.
And how about the response in 16087?
It's regarding the issue of responding to
A request from the
different
task
issue.
force, okay.
Yes, which does not appear to be the complaint.
What would be your recommendation again for moving forward?
I was going to pull the response from the library from 16085 and place it into this file. And in our recommendation when we write up our write-up on this matter, we will also inform that the library that this issue is the issue addressed in 16085 really should be addressed in 16087.
Okay. Mr. Hartz, do you mind taking a minute to respond to this potential way of proceeding? Because it seems like we're struggling to match up the file and the complaint, and I'm looking for what you're saying, and that's not matching the emails that Ms. Blackman has. So if you could limit that to a minute, but engage in this discussion with
No,
us.
I'm fine with that because it does resolve the issue. Again, my issue is Ms. Blackman has gotten in a pattern on all the complaints of putting in derogatory comments and personal comments against me. And it is unclear whether or not she is doing this on her own volition or whether she is doing it at the direction of her boss, City Librarian Luis Herrera, or the Library Commission. But since she claims that there were no communications between any of them, it couldn't, from my perspective, be anything that somebody told her to do. So then it becomes her personal animus, and very frankly, when a city employee starts to insult members of the public and challenge their methods and motives and all this other stuff in writing, and then comes out and says, well, nobody told me to do this, I think that's abuse of authority.
Okay. So from hearing from what Mr. Hart says, it seems like the request was actually for information from the library on, if Ms. Blackman is receiving direction from management or is working under her own authority, and how that might be coloring the comments that she is placing into her responses. We will proceed under the recommendation from our clerk, Mr. Young. And thank you, Mr. Hartz, for your comment on how we will be proceeding.
I assume that it would be a motion to refer it. We haven't
To the
given
clerk
Mr.
for
Hartz an
cleanup.
opportunity for rebuttal yet.
Okay.
But I believe the motion would be to refer this matter to the task force for hearing with my recommendation to pull information from the previous file and place it into this one.
Yes.
I believe this is Mr. Hartz's rebuttal at this time.
Ray Hartz, Director, San Francisco Open Government. I really do believe that if pressed, Ms. Blackman cannot show a single example where I have done anything outside the law. In other words, I go to public meetings and I make public comments. I file a complaint if that is interfered with. I request public records, and if I am not provided those records in an appropriate fashion, I file a complaint. Those are all lawful activities, and she mischaracterizes in not just this letter, but in a number of letters. In fact, it seems to be a pattern for every response now that anything I do is harassing them. And then she goes in and includes these personal snippets where she presents something which sounds really bad on my part without really telling taking any time to explain it. And one of the reasons Ms. Blackman has taken a personal dislike to me and told another member of the public that she hates me is the fact that for years she was allowed to write the minutes of the Library Commission meeting and put down anything she wanted. In other words, she could write her opinion, her version of what you said, and if it was objected to, she got all offended. She said, I'm only summarizing it. And I say, no, you're abridging it, because sometimes you leave the important part out. Sometimes you put things in that I never said. So, and this is all documented in Library Commission minutes. And Mr. Warfield also has had the same problem. You get up during the minutes and say, you know, this is inaccurate. This is wrong. And they will just ignore you and approve the incorrect minutes. And so at this point, I want to find out, is Ms. Blackman acting on her own, or is she being directed? But in either case, the fact is she is representing both the Library Commission and the library. And if they have simply allowed her to put in these kinds of comments, they are still responsible for it, even if she's doing it on her own. You know, if I'm your boss and you do something inappropriate, I can't say, well, it's not my responsibility. It's all your fault. I'm your supervisor, and Mr. Herrera is Ms. Blackman's supervisor. And I don't know how Mr. Young directs these, whether he sends a copy to Ms. Blackman or whether he sends it to the Library Commission and the library in addition to Ms. Blackman. And I find it kind of odd that Ms. Blackman would be the only one to get the copy and then wouldn't share it with anybody. I want the bad behavior to stop. I've petitioned the Library Commission. I said, she's representing you, she's talking badly about me, and you need to take responsibility.
Thank you. Any other public comment on this item? Mr. Bowe?
Yeah, I think slandering somebody in a written letter, particularly on the letterhead of a department, is a very damaging thing. It might not conform exactly to the Sunshine Ordinance. There might not be a specific section that you could cite, and I don't think there is one. But I've been a victim of it myself, and it's shocking to read those kind of things, actually. And for somebody to continue to go back to the commission that is doing this is kind of, I don't know. Yeah, I can understand why he would want it to stop.
Thank you. Do we have any other public comment on this item? Or on the motion, excuse me.
Can you repeat the motion?
The motion is to defer the matter to the task force for hearing, along with a copy of the committee's discussion and issues of discussion.
And also adding the information from the file number 16085 to this file.
Thanks. I'm Peter Warfield, Library Users Association. We're not a party to this, and I'm not familiar with this complaint, but I think there are some concerns here. The mixing up of items so that they're not making sense. I think the agenda packets need to be in correct order. That is to say, they should be in the correct order. There's something a little bit troubling here with respect to the discussion, and it seems like it was on previous matters as well. It seems as though you are requiring all of the burden of proof to be on the complainant, and there doesn't seem to be any will to do what you are perfectly entitled to do, and which past task forces have done, and that is to be active about finding out, if we can call it, the truth. If Ms. Blackman didn't have any copies of this and she sent a 4-page letter, which frankly sounds to me like she was consulting with the city attorney, I don't think Sue Blackman would write this 4-page letter with all this kind of language on her own. For example, on page 72 in the middle, the city charter empowers the Ethics Commission to, quote, adopt rules and regulations. She goes on and on with the charter, section 15.102, and then in another parenthesis, Ethics Commission regulations for handling violation of the Sunshine Ordinance, chapter 1, section 2, sub U at page 4. I think clearly at least she has been consulting with the city attorney and maybe having the city attorney draft this. But I think you are absolutely well within your, really, I would say, duty and obligation, finding out from her and the whatever agency is up, how do you do this? How did you write this letter? Did you get direction from anybody? In what form was it given? Was it oral? Did you ever show this? Did you send this to somebody? Didn't you send a draft to anybody? When Bruce Brugman, the editor and founder of the Bay Area, the San Francisco Bay Guardian, was on this task force for some 10 years, he would take a very active role, and other members as well, in questioning people who came before this task force and ask him, what do you do? How do you do it? How did this happen? He was banging on the table one time. He didn't want the library making claims if they weren't willing to back them up, i.e. give me the documentation. So I think you need to be very active about, or more active, and feel fine about it. Well, how did this come to be? And find out from them what they did to produce a document like this, which is so really outrageously insulting, and it's a libel. Thank you.
Can we call a vote on the motion?
On that motion, we did not have a mover or seconder, but I
thought Member Bernetsky made a motion. for this
I
item?
believe so. I wasn't clear on the motion
I
actually
don't
being made.
think she did because I didn't second it. I didn't
Second it? Okay, do we have a motion on this item? We're going to have to redo all of the comment.
No, we can just make the assumption that if Member Barnetsky would have, would you like to assume the motion?
So assumed.
Do we have a second?
Second, she was.
The motion was stated, but it was never officially made by a member because I stated it.
Oh, but you, okay, thank you.
On that motion, Member Barnetsky.
Aye.
Barnetsky, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes.
And clerk, can you call the next item, please?
Next on the agenda is item number 8, file number 16057, complaint filed by Antrebo against Howard Lazar and the Arts Commission for allegedly violating Administrative Code, Section 67.25, by failing to respond to a media disclosure request in a timely and/or complete manner.
Mr. Bowe?
Jurisdiction.
We have a motion for the jurisdiction.
So moved.
Second.
Thank you. And we take that without objection?
Assuming there is no public comment, we will adopt that without.
Is that why you're here, Mr. Bowe, for
No,
okay.
it's her item.
Oh, yes.
It's mine.
Okay.
There is no public comment on the item. This matter is the motion to find jurisdiction is adopted without objection.
Okay, this is classic Howard Lazar. Page 106 is kind of a summary and a timeline in an abbreviated version of what took place because it's very time-consuming to read through repetitive documents, which is very often what the Arts Commission does. They don't supply the documents that they send, they just repeat the email string over and over again. So basically, I made the IDR on the 26th of May to Howard Lazar because he was the one who had these documents, and they would have been, it would have taken 10 minutes, a simple routine request to pull them out and send it. So on the 27th, he asked for clarification, which is what he always does. So when I responded not only to him, but to Rebecca Krill. I had sent the same IDR on May 25th, prior to this one, to their generic record request, and nothing came back, which is why I sent it directly to him. So on the 27th, I gave him the clarification that it was just a repeat of the original IDR, and I never got a response back. So suddenly, a month later, on June 23rd, page 126, is the original IDR. So what is, and then suddenly and out of nowhere on July 7th came the Arts Commission's response. There was a full 3 weeks in there where they didn't invoke an extension. They didn't do anything. I believe I called. I left a couple messages. I never get a response that way. Nobody ever picks up the phone. So what I didn't receive in the document request, the original one, is a copy of the legislation with the file number and the Board of Supervisors agenda. It's a simple thing. It would have taken 10 minutes to send it to me. And all documents concerning street artist spaces on Stockton Street between Post and Bush for the past year. So I didn't get that bunch of documents, and since they didn't supply what they sent, it's kind of up in limbo land. And then once the notification went out to the Board of Supervisors, they had 5 days to respond. They responded after the 5-day period. So it was 6725A, a late response. It was an incomplete response. I followed up with emails and got nothing.
Thank you. Do we have any more speakers in support of the complainant? The respondent isn't present. Do we have any questions from the task force? Can we bring that for discussion now? I have a couple of questions for Ms. Trudeau. Member Hinsey and Member Bernetsky, do you have any questions? Nope? Okay, I'll go ahead. So part of your request was for some legislation.
Mm-hmm.
Did you request this information from the Board of Supervisors? Did you have any luck with that, or did you try that? Or
this came by way of an audio of a hearing that took place on May 11th. Mm-hmm. Howard Lazar is always very vague. He's very patronizing. So he just made a statement. The Drum Street spaces passed the full Board of Supervisors. That was the statement. So I was looking for more information in that way.
On that statement.
I could not have gone to the Board of Supervisors with that small bit of information.
Okay.
So, and then when I responded to him, I clearly said what I didn't receive on the 26th, and once again, Rebecca Krill was copied. So there was that. The response of July 7th from the Arts Commission is just completely invented. It's on page 133. Mm-hmm. It was not a complete response by any means. There was no assistance. Why don't you go look at the Board of Supervisors? I'll try to get the information. Nothing of that nature. And what eventually they gave me in July was a link. So this was a simple request that would have taken 10 minutes to respond to. So when they're talking about the first and second responses, they never supply the documents in the packet that they say they send. So it's very confusing. It's hard. It's very picky to trudge through and try and keep track of of this verbiage because it's the same thing over and over again. If they just include the documents they send, it would have been a lot easier, but it's not. So this was not sent exclusively to Howard Lazar. It was also sent to Rebecca Krill, his boss. So,
And just a quick follow-up for that. So I was looking through the email chain, and then Howard Lazar asked you for clarification, correct? And then in the response from Kate Patterson on June 27th, she provided you with that link. And that was the first response that you've received since your clarification, correct? Or did you receive anything from Howard Lazar?
absolutely not. I sent.
Okay. So the first response was this one with the, after Mr. Lazar requested clarification and you gave the clarification, this was the first response you received.
Correct.
And can you go into more detail on why this response was not enough? Because she did provide the link to the legislation with the relevant documentation.
I needed
about the four spaces.
The purpose of an IDR is to get information quickly. I was preparing for oral arguments at the California State Court. I needed that specific information in a quick manner. July 7th was way late after I needed it.
But was the request for clarification timely? Would you say
It was sent the next day.
Okay.
And it was very clear. And I mean, he does this all the time. It just makes these things so voluminous. I asked for the legislation, the file number, and a copy of the agenda. How could I clarify that even more?
Okay.
It's very simple.
And so the violation for clarification is that the response that came to you on June 27th wasn't timely.
It was not timely, and
Okay.
then suddenly and out of nowhere on July 7th, after I file a complaint, then they come up with a response which is essentially invented. If she had just provided the documents that were sent to me, then everybody would know what was there. Instead, we get repetitive nonsense. It's a clear violation of 6725A, but I think it was not a complete response. There was no assistance in the matter. It's just, prodding them and leaving messages and follow-ups and flagging it. It's very tedious.
Okay. Member Hinsey, do you have any questions?
Not at this time, thank you.
Member Bernetsky?
No.
Okay. Is it time to hear a rebuttal, or should we have a motion?
You can take the rebuttals, then make your motion.
Can we hear a rebuttal, Ms. Trudeau? And also hearing some of the concerns that I've raised in my questions, if you could speak to that.
Well, in the
Your
city
final
attorney's
statement.
memo, he raised some issues. Is there any way to prevent an RDR from going into an employee's trash bin? Because that's been a familiar excuse for Howard Lazar, or he didn't receive it, or he didn't know how to take it out of trash. I've heard all kind of excuses of that nature. So clearly he received it. Rebecca Krill received it. And if something is flagged in IDR, they had a responsibility to at least acknowledge that they received it or send it to the correct person. And the fact that I filed the exact same IDR to their generic email the day before, only, it's an attitude problem, record keeping, that kind of thing. It's not the first time they've done it. They just don't want to give information, I suppose. I don't know.
And could you speak to how this record request, you have a number of requests later on in the agenda, and so this one isn't related to any of the others? I just wanted to get...
This one was of great concern to me because there was a claim that he had gone to the Board of Supervisors and gotten additional spaces, but it was a very vague statement. There were no supporting documents. I had asked for that information previously.
Okay. That's fine.
Okay.
So it appears here that the request for clarification was timely, but the actual information that you received is what you feel is untimely. Okay.
Yeah.
Thank you, Ms. Trudeau.
Okay.
Can we get a motion on this item?
I move to bring this item up to the full task force for hearing.
Do we have a second?
That's it.
Second.
Thank you.
Is there any public comment on the motion?
Mr. Warfield?
Peter Warfield, Executive Director of Library Users Association. We're not connected with this in any way and not familiar with it other than from what I've heard. Unfortunately, there's only one copy of the full agenda packet, so when I was looking for it, I couldn't find it until I noticed your complainant using it. We had some experience with the library, with the Arts Commission a while back when there was some issues regarding art on a library wall that the library wanted to get rid of, and which the Arts Commission had a role in. And we found the Arts Commission extraordinarily arrogant, unpleasant, generally speaking, and not very cooperative with respect to records. We filed multiple complaints and had several wins here at this task force. This is an example that I can only think of as being another in a long series, not just the complainant, but ours too, and others. We didn't actually have any quarrel with Mr. Lazar at that time, but Kate Patterson was involved and so on. But the Arts Commission is an example, I think, of a repeat violator. In listening to this, somebody asking for clarification, I don't think a clarification request stops the clock. If Mr. Lazar or anybody else doesn't understand something or is unclear about something, then I think the clock continues to run, and it's up to the respondent to do the best they can. And they sometimes do that. They say, we understand your question to mean such, and that's the basis on which I'll proceed. I've seen that done, and that's reasonable. You look at it and you say, fine, no problem. Or you say, actually, I didn't really think of it this way, and so on and so forth, so they can change what they're doing. But I don't think that it should be allowed to or used as another impediment to the requester getting the material or as an extender of time. There needs to be some point at which these endless complaints. I want to tell the story about growing up in New York and going to college in New York, and I had a very cheap apartment in the Village in New York, and there were times when I'd come home and get my rolled-up newspaper ready. I'd fling the door open and run to the middle of the room, pull the light on, and the cockroaches were running every which way, and I'd whack and whack and whack and whack. There comes a time when you have to decide there's an infestation. Not just you're going to bang this one, and you're going to bang this one, you're going to bang this one, you're going to bang this one. And the Arts Commission has been, seems like an endless series of complaints, including the complainant has won many, we've won, and I'm sure there are others. And I think it's time to say to them, you need to get serious about complying with the law, and we're not going to just take complaint after complaint after complaint the same way, find violations, and have you proceed. I think at the very least you should strongly consider willful violation because of their record. Thank you.
Thank you. Do we have any other public comment? Seeing none, can we take a vote on this item?
On the motion, Member Baranetsky?
Aye.
Baranetsky, aye. Member Hensy?
Aye.
Hensy, aye. Chair Tesfa?
Thank you. Aye.
Tesfa, aye. The motion passes.
Please call the next item.
Next on the agenda is item number 9, file number 16068, complaint filed by Anthropo against Kate Patterson and the Arts Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to immediate disclosure request in a timely and/or complete manner.
Ready?
Not quite yet.
No, not yet.
Okay.
Can we have a motion to find jurisdiction on this matter?
So,
Second.
Thank you. Can we take that without objection?
Is there any public comment regarding jurisdiction on this matter?
Mr. Warfield?
Peter Warfield, Library Users Association. I just would like to take some credit for not having commented on jurisdiction questions and taking your time up in that fashion. But yes, basically, we think you should take jurisdiction on this, subsequent ones, and of course, past ones. Thank you.
There being no other public comment, can we adopt a motion to find jurisdiction without objection?
Thank you. Mr. Beau?
On page 149 is my summary of this complaint. So an IDR was sent on the 14th at night, so by the 15th, end of business is when there should have been some response. There was no auto away message returned to me at all, not in any form. And the one that Kate Patterson pulled up as some kind of evidence, this is a trick they very often do. Page 150, you see two differing emails. For some reason, Ventry is sending an email to Howard Lazar claiming that she's away. That format, the font is not near the same as the one below it. And why would they include both of them on the same page? Because they're forged. They just don't follow the same format. When one email account is being sent to different places, it's always the same format, it's always the same font, and it's always set up the same way. So why are those two different? Because they're forged, and I've seen that very often. You see the cutting line, the two lines between the two, the additional information on the bottom one. So the original IDR is page 151. A simple thing, I just wanted to one set of things for a couple days, which again would have taken 10 minutes. It was sent to their generic email, and in the morning. Once again, there was no audio away message that returned to me. I also called her phone. There's a very long-winded message, and I left it nothing to say she was gone. And I said I requested response. On May 18th, which is a late response, Kate Patterson sends the same documents she sent the month previous, so they weren't responsive to the time frame that I asked for. And I emailed back saying these are not the correct documents, copying other people there, and asked for the correct documents. And she said, no, the case is closed. And then I've corrected her so many times on this. I actually counted 41 times. Article 1, Section 1 of the California Constitution doesn't even pertain to an individual's right to privacy, but she continues to make that mistake. So it's a late response, and the documents were not provided to me. That's it.
Thank you. Do we have any other speakers on behalf of the complainant? Okay. And because the respondent isn't present, can we move to questions from task force members for the complainant? Does anyone have any questions? If not, I do, but okay. If we can look to Mr. Beau, hi.
Yes.
If we can look to page 150 of the packet, and I was wondering if you could maybe just go into a few more details on why you think this is a forgery. My first question has to do with my out-of-office email changes. I make it specific. Usually when I'm going out of the office, I'll say something like the dates that I'm gone, when I'm returning, and I have to edit that every time that I put out an out-of-office message. So looking at this document, can you show me what made you think that, or think that this is not a real out-of-office message?
Well, first off, page 153, which is Kay Patterson's response on the letterhead of the Arts Commission, was written on August 22nd. If you look on page 150, which is the two emails in question, you will find that it is sent the same day, August 22nd. So to me, that gives me pause to wonder, was it a coincidence that happened on the same day?
I thought August 22nd was the date that she was forwarding what her old out-of-office message was. That's how I read it.
That's how I initially looked at it, but since they've provided this type of thing as a response so many times, if they provided a screenshot of her outgoing messages,
rather than forwarding.
And if you saw an outgoing message was sent to my email, I would say hands down, maybe I didn't receive it, but one went out. This is a technique that they use. They've used it for well over 2 years. By forwarding emails from one employee to the other, it gives you an error of doubt enough for them to say, no, we sent from one employee to the other. There's no evidence that anything was sent to me. So in answer to your question, why do I think this is a forgery? Well, first off, they've done this so many times. So it made me look at it very carefully. So we have Ventre sending Lazar, maybe forwarding him an email. Why would he do that if Kay Patterson is responding? First off, that's the top one. And that is usually in their email chains, that's how the things look, with the stuff on the bottom, and we've moved, and yada, yada. The one below it, and particularly the two lines, it leaves me to wonder, did they cut this? Was it altered? Why are they forwarding it from... could be 4 people that they're forwarding, but not to Kay Patterson, which is the oddest part about it.
Okay, that's helpful.
Oh, okay.
And I think that's something that we're going to have to ask as the complaints committee for the respondent as they come forward, is for them to get some work from their IT to show that something was an out-of-office message. I have my sent...
The Compliance and Amendments Committee has requested information from the Department of Technology regarding the out-of-office message, and they're going to have a meeting on this in their January meeting.
Okay, that would be great, because I know, I use Microsoft Outlook. It's obvious they use that as well, and when I have an out-of-office message, it doesn't appear in my sent box. And I know because I get I get many of and when I'm out of office, I would have had at least 30 or 40 a day of my sent box showing that I had an out-of-office message pushed to all of these people, and none of them appear in my sent box. So we'll have to get some clarification on that. I agree with Ms. Trudeau that what's being forwarded is not clear as to what's an out-of-office message or not, especially when it's forwarded around the same time as the complaint. I've definitely had out-of-office messages go to my coworkers who have sent them back to me saying, hey, your out-of-office message has something incorrect, has the wrong year or the wrong date of your return or something like that. And those are the only instances that I ever know what my out-of-office message, if it's incorrect or whatever. Anyway, committee members, do you have any other questions for Ms. Trudeau?
No.
Okay, thank you, Victor, for that, or clerk, for that extra information on what's pending.
And this is probably a larger subject matter, but we have asked that the Arts Commission develop a central email address to receive immediate disclosure requests, so it's not dependent on individual persons. So this has been a long-term issue with the Arts Commission. They have developed that email address, And I'm not sure how they should proceed in the future, but maybe they should send it to both addresses, to the person and to the main address.
That makes sense.
But sending it, this is a long-term problem, and sending it to individual members while they're out of the office,
We can see
they
there's
can't
a record of
respond.
cases here.
But
too.
it's a matter of the issue of whether or not the auto response was sent or not is a different issue. But
Yeah.
to ensure that the department gets it, they should probably send it to the main number or the main email address.
Is the issue that CNA with the out of office responses, is that specific to the Arts Commission?
No, it's not. This is an issue that's been brought up by other departments.
Okay.
And we're
If
trying
that-
to find out whether or not they can generate a report of who was sent an out-of-office message and so forth. But this is an IT issue, and it's not an Arts Commission issue.
Okay.
If I may?
I see that Mr. Bowe would like to speak, but before so, can we have a motion and then you can make your statement? Do we have a motion?
I believe the motion would be refer this matter to the task force for hearing
Okay.
with a summary of today's discussion.
Okay, before that, should we hear the rebuttal from Mr. Bowe?
Oh,
Yeah.
yes.
Yeah.
Okay, can we hear your rebuttal, Mr. Bowe?
There's an important bit of information I left out. On page 151 of your packet was the first request that I made to their generic email, SFAC records request. So it did go to their generic email. And then a second one, the first one was sent on the 14th, and then I resent it to that email on the 19th.
Thank you, Mr. Ridden.
Okay.
Do you have anything else in your rebuttal, though?
Just the lag time in between. The first response of the Arts Commission was August 22nd, which is suspect since the original IDR was on May 14th. And then November 16th, they responded again, page 149. But since they never supplied the documents that they claim to have sent, it puts the burden on me, the complainant, to print it out. And since the first data dump was the wrong set of documents, it just is a waste of paper, basically. And you have to read, and everybody has to sort through it. So that's it.
Thank you. Do we have a motion, Member Baranetsky?
Yes, I'd like to adopt the motion that Victor mentioned, that this be brought to the committee.
Second.
And can I amend the motion to also include any information that the Arts Commission can provide on their...
Out of office.
Yes, regarding out-of-office messages and some type of formal documentation from their IT department or something like that on what the out-of-office message is, so that we're not dealing with this kind of forwarded message that we see in the packet, which is all that Mr. Bowe is able to provide us.
Can I second the amendment?
Thank you.
Is the seconder?
Yes.
Thank you.
I will provide that question to the Arts Commission.
So, yeah, so that when Mr. Bowe's hearing comes, we can
However,
kind of
I
get it all done.
have, there's a possibility they may refer us to the Department of Technology, since they're just using the Department of Technology's email
Okay.
accounts.
Thank you.
Public comment on the motion.
Peter Warfield, I support the motion. I'm not a party to this, haven't been familiar with it, but I have to say this is now the second of what look like 5 absolutely identically worded agenda items. First of all, I wish you would have more specificity in the items so that somebody who even has filed the complaint knows which item number refers to which complaints, by date, by subject, or something. These are not all exactly the same complaint, although the violation, the law section that's been allegedly violated is the same. Once again, I think you're in a position of over and over and over and over again having violation after violation, and I think that you need to put your foot down on departments and say, you have to get an understanding of what the law is. We've had so and so many violations against you in such and such a time. They are repetitive. We're tired of this. I'm certainly tired of it. I'm sure you are, and you'd save a lot of time if you got, I think, a little tougher with the departments. I also think that you should be requesting, and I saw this somewhere perhaps in your newly revised procedure, I think you should be asking for principles, meaning you should be asking for the people that did the action and not have somebody third hand talking about what happened. I'd certainly recommend that in the case of our complaints, but I would recommend it here. I would certainly like to see Kate Patterson and Mr. Lazar so that they could be here for you to ask them questions.
They will.
Also, and I think that should be specified, because as long as you allow anybody else to speak to the issue, you're just going to get second-hand, third-hand, which you wouldn't allow in an actual court. There's also the issue of, don't they have filters? If you have a media disclosure request, as it's required in the law to be put in certain places, like the subject line, don't they have a filter where they can get everything that comes to the department that says a media disclosure request in the subject line going not just only, but perhaps additionally to a sunshine request folder? You seem more up on these things than perhaps I am, but it seems to me that the requirement to put a media disclosure request in the subject line means they can put a filter, and there should always be, certainly when somebody's out of the office, there should be, as with phone messages, a specific who else to get in touch with and a forwarding so that that phone call will be dealt with and that email will be dealt with in a timely way. Thanks.
Thank you.
There being no further members of the public in the room at this time, on that motion, Member Baranetsky.
Aye.
Baranetsky, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. We are approaching 7:30. However, I'd like to take a look at the next three items in that they appear to me to be related to the same original requests for records.
Me as well, yeah.
16078, actually 1607 was filed on 8/5 regarding specific records. 16072 was filed on 8/10 for the same records, and 16078 was filed on 8/12 for the exact same records. I believe the complaints are based on responses from the department, but they seem to originate from the same original IDR request. And I don't know if you would like to work with the complainant to possibly combine these complaints into one or something to that effect.
We're approaching 7:30, and I would like to briefly discuss that among our members. And the time, we announced that we were going to be ending at 7:30, and that's what I would like to keep the plan. Mr. Bowe is here. So if this is amenable to the other members, I would like to ask Mr. Bowe if she can combine these three items. If she cannot, then we can move all three to our next complaints committee meeting. If she is amenable to hearing, given the similar nature, hearing this item right now with the time constraints she has on her speaking time, if she's amenable to that, we can listen to them now.
I would agree.
Is that okay with you guys to ask
As long
her?
as it's not rushed, yeah.
Except because of the three responses, that I would get 15 minutes. If I need it. I don't think I need that much.
Members?
It'll be 9, not 15.
Yeah, it would be 9. It would be 3, 3, and 3.
Okay.
Members? Member Hinsey, Member Baranetsky?
I agree with this.
Okay. Should we take public comment on that? I believe this is up to Mrs. Trudeau. It's her case, but...
I believe, I just wanted to clarify, are we combining all three of these files into one complaint file?
Correct. So that, yes. But she would get she would get to do her 3 minutes concurrently to speak on all 3 items.
I believe that we would combine 2 of the files into, we should combine file number 16070 and 16072 into 16078, so there will only be 1 complaint file.
Yes,
I'll
it'll be-
consolidate all the documents into 16078, and only that 1 file is to be considered at this time.
But all of the documents would appear.
Yes.
Okay.
And would you like to make a motion to combine those 3 files?
I would like to make that motion,
I'll second it.
and then if we can hear public comment on that. We've heard from Ms. Tripp.
I feel so because it's fresh in my mind, whereas,
Okay.
it will probably be January.
Peter Warfield, not a party to these things. I don't know that you want to combine them into 1 file. I certainly would support, with your time limit, putting them all forward for a hearing at the full task force, possibly without further discussion amongst yourselves. And I would be willing to give up my 3 minutes of public comment on each item as well, in the interest of going along with your planned.
But we would want
Deadline.
all of the
Deadline.
documents combined into 1 file so that when people are making reference, they have all of the documents. She's going to make reference to several documents, and so
Yeah.
I want them to all be in 1 file so that we can,
I think the first person that should be asked is the complainant, because that's the person who has prepared for this and would be probably the most, finding the most confusion or difficulty as a result. So I would certainly support whatever her answer is. I just asked her, and I think I have an idea to streamline this, but I certainly would think you'd want to ask her particularly. And
well, she
as to
heard
what her
she heard
opinion
that
is.
was the proposal.
Yeah.
So
okay, so it's
I want
okay
her to
with
be able
it's
to use
fine.
all of the documents
Yeah.
when she's speaking, not just from a specific file.
Yeah, so I would support that.
Okay, thank you, Mr. Warfield. Okay, so given that, if we could give you your 9 minutes.
On the
We should find the motion to find jurisdiction, yes.
On the motion to combine the matters,
Files.
Oh, combine the
that-
files.
may we adopt that without objection?
Great, thank you.
On the motion to find jurisdiction on 16078, I will read that file in its entirety at this time. 16078, complaint filed by Anthropo against Kate Patterson and the Arts Commission for allegedly violating Administrative Code, Section 67.25, by failing to respond to immediate disclosure in a timely and or complete manner. Is there a motion to find jurisdiction on that matter?
So moved.
Second.
Is there any public comment regarding jurisdiction? There being no public comment on jurisdiction, may we adopt this without objection?
Great, thank you. Mr. Bowe.
Okay, first off, I would like to include Howard Lazar in the heading, since he is responsible for this. The narrative is on page 291. I sent the IDR on August 2nd at night, so I should have received a response by August 3rd by close of business 5 p.m. Instead, I got a response on August 5th. Patterson's response is Lazar's day off is Wednesday. I provided you proof in the packet of inspections done on Wednesdays on multiple dates. So his day off is not Wednesday, it is Friday. So that's a blatant lie. No audio away message returned to me, and Patterson hasn't supplied evidence of an audio away for that date for Howard Lazar in a response. I once again called his phone and left a message saying I emailed a document request, and there was no recording that he was out of the office or to refer me to somebody else. So the August 5th response was written by Kate Patterson. It's in her same ranting verbiage, same tone, same authoritative diction, which follows all of her previous emails, and I've been reading them for over 2 years, so I think I can speak to that. So the document request was not satisfied. I asked for the full file of Maria Sky, and I find it inconceivable that they wouldn't know her under her married name since she's been a street artist for 35 years. She attends all the meetings. She's on the lottery committee, and she meets with Howard Lazar on a daily basis. And I've also provided in the documents on one inspection, she was showing him her wedding photos. So, there was ample evidence that they knew that she had a different name. That the claim that they didn't know she had a different name just doesn't seem to make sense. They should have invoked the 14-day extension, and they should have supplied the documents that they sent to me. They did invoke an extension, but all I got was 20 pages of random documents, which I included in the file, and they had nothing to do with the request. That was not a Maria Sky documents. And this claim of offsite storage they've used so many times, that's an excuse. So I once again notified Kay Patterson by email that I believe there were more documents on this Maria Sky thing, and I didn't get anything. So, and then she mistakenly sent me a PDF of something that had absolutely nothing to do with anything. And that's why these email strings are so long, because I'm constantly on her saying, excuse me, you sent me somebody else's file. So the second part of the IDR, all written correspondence between Barbara Scalar and the Arts Commission for a certain time period was not satisfied either. I thought there were going to be legitimate communications between this specific person and the Arts Commission. Instead, I got a bunch of generic solicitations to all commissioners about events in City Hall, shirt sizes, canceled meetings, and I asked for a specific time period, and Kay Patterson only supplied the same documents to me 3 separate times, which is why this file is so thick. She just keeps spitting out the same thing. So the last part, no documents were supplied to me at all. I asked for a Fama Tam file. She's been a street artist for 25 years. I was told that there were no documents. I find that impossible to comprehend. There are documents, and he just didn't want to go look for them. So there's a number of violations going on there. The last file number is a similar thing as Ray Hart's. For some reason, when I was asking for specific documents concerning Barbara Scalar and the Arts Commission, Kay Patterson reads into it that I'm looking for private emails of commissioners, and she goes on this long-winded rant about how Barbara Scalar has a restraining order against me, and she talked to Sharon Page Ritchie. I mean, this whole thing is so completely off topic. It wasn't near what I asked in the document request. And then even on the letterhead of the Arts Commission, which was disturbing to me, she accuses me of going to commissioners' houses and offices for the sole purpose of harassing them. What does that have to do with a document request? And then she copies Margaret Baumgardner, city attorney, who I had seen in my oral arguments, and she lost the case, and that was after the order reversed. It's just a mishmash of repetitive, annoying, off-topic nonsense. So page 482, I think, is that specific letter where she goes off and slanders me in writing on the letterhead of the Arts Commission. That was so disturbing to read that. And that's been her pattern of behavior for a very long time. This is a number of violations. The late response, the fact that I didn't get the documents that I requested. I continued to follow up and ask for the correct documents. They never sent it. They did copy Victor in some of the emails. A lot of the emails I didn't get. Pages 200 to 290. My first time of seeing this was when I looked at the packet. I never got any of that. So, I don't know if anybody wanted to waste their time by going through this, but this document request was not satisfied in any shape or form. It was a bunch of lies on the part of Kay Patterson. And that's pretty much it. So the letter that I'm referring to is page 489 to 491 in your packet, written on August 31st, after oral arguments and after an opinion from the California State Court was filed. So why would she be copying Margaret Baumgartner? I don't know, since Margaret Baumgartner was in court. So she goes through her babble, and here on page 490, now she's moved off, completely off topic, and believes that in this document request, I'm asking for personal emails of commissioners. That was nowhere in that document request. And rather than risk turning over the private emails, given Ms. Trudeau's history of contacting commissioners via their personal phones, emails, and also showing up at their residences and places of work unannounced, we believe this was a prudent decision. The order had been reversed by that time. There was no evidence of this, and she still continues to slander me on the letterhead of the Arts Commission, which was the basis of the last complaint. So that's it. I believe there are a number of violations there.
Thank you. Do we have any comments in favor of the complainant? Okay, seeing none. Task force members, do you have any questions for Ms. Trudeau? No. I do, if you don't mind. So looking at the packet, so Maria Sky is Maria Hilius, right?
She had been Maria Hillis for easily 20 years.
Okay, so that's, I just want to make sure I'm looking at the right thing.
Yes.
And so this information was eventually provided, correct? It was provided?
No. My first time of seeing this information was when this packet was posted online. I don't even know how it got there. I certainly wasn't copied on it.
Are you sure it wasn't in any of the documents you provided?
No, I printed out the documents that I provided, and my response was stamped in, so it happened after my response.
Mm-hmm. Okay.
And that was not within the 5-day window prior to the hearing.
Got it.
Okay.
And the information that you requested on FAMA TAM, was that information eventually provided?
Never.
No?
I was just told there were no documents.
That's helpful.
No, I never received anything.
And then there was also the request for a draft agenda. In that case, a draft agenda could have possibly not existed, right? So
Right.
Did they state that there were no responsive documents, or did they say that you weren't allowed to receive a draft agenda?
I believe no responsive documents,
Okay.
which is why I didn't mention it.
Okay, I just wanted to clarify.
Yeah.
So it looks like we have a couple of questions here, and we'll need to have the Arts Commission make sure and explain why the information on Maria Sky, Maria Hilius now appears in the packet but wasn't provided to Ms. Trudeau. And then we'll also need to find out when the information on FAMA TAM will be provided, if ever. Did they state? Sorry, let me ask again. Did they state that there were no responsive documents?
Yes.
And that, but you know that this person has been working with the Arts Commission for years, and there should be documents. Was that the issue?
It was Howard Lazar who wrote it, and he said, First, he asked for the clarification. What do I mean by FOMA-TAM? I supply the clarification, and then he says he has no responsive document.
Okay. Do we have any questions? Does anyone else have any questions? Do we have a motion at this time? I mean, it looks like, what I'm thinking, I mean, it looks like we've got definitely a failure to respond to the IDR for Marie Hilius. I think it's kind of unclear about what's going on with the information from FOMA-TAM. It seems like, I mean, from the packet, it looks like Howard Lazar says they don't have any information, but then Ms. Trudeau is able to provide limited documentation, that there should be documentation, because she's been working, FOMA-TAM has been working with the Arts Commission for many years, so.
I've been to a lot of her hearings, and I know they're public hearings, and there has to be documents.
So it'd be good to have the respondent present, of course, at their hearing to give us some follow-up on that. And we need to make sure that we can include that in the motion, that they make sure that they include that information. And then the issue of the draft agenda is not one that Ms. Trudeau has placed much emphasis on, given that the response was there were no responsive documents, and that could very well be the case. Do we have a motion at this time?
I move to.
Sorry, did we get a rebuttal from Ms. Trudeau?
Not yet.
Can we get the rebuttal? Member Hinsey, do you mind if we get the rebuttal first?
Of course.
Okay.
How much time do we want to allow for a rebuttal?
How much time do we usually?
It would be the 9 minutes. It would be the 3 minutes. But Ms. Trudeau doesn't have to use that full time, but we'll give her 9 minutes. Are you ready?
Yeah.
Okay.
So the page 484 to 486, a letter written to Victor Young on the letterhead of the Arts Commission on August 31st doesn't even quote the full document request. So Patterson didn't address FOMA-TAM in that. Instead, she devoted, this is a 4-page single-spaced letter. Half of it goes off completely off topic and talks about I accuse the Arts Commission of wrong redactations of commissioners' public emails. That wasn't in the document request. And then she goes off onto private emails. So easily half of that was so far off the rails that there was no mention of the original IDR in total.
Mm-hmm.
And in previous complaints a year and a half ago, I asked when Patterson shows up here, she's always talking about extensive files in their offices where I'm supposed to be doing things to people. I asked for those files, for those documents, and she's admitted numerous times that there are no documents. So how can she continue to write these claims? Does anybody look over what she's doing? You know, I have all these questions that, just look at the sheer volume of this file. It's all the same thing copied over and over again. It's really unbelievable. So, and what makes it so voluminous and so hard to track is that, once again, she's saying installment of records. Well, how many installments? How many PDF attachments did she send? We don't know. And the first one was the mistaken file. This Barbara Scalar file was not a Barbara Scalar file. So it's extremely hard to track. The documents were not provided for me at all. Did Patterson correct her mistake? No. and she didn't comply with the record request. It was, the problem is Howard Lazar began to answer it, and then Kate Patterson sent an email under Howard Lazar's email address, so it quickly gets so messy and so hard to track for anyone. It's a pretty simple thing. Here's the documents. You know, departments come in, some have files. They say, well, here's the documents. If you didn't get them, here they are. It's pretty clear and straightforward. Not so with the Arts Commission at all. She's come in here and fooled around at the last minute, claiming, oh, here it is. Here's the thing I sent. You know, it's just not cool.
Do we have a motion?
I move this item up to the full task force for hearing, with emphasis on the items that we spoke about today.
Okay. And that will include having all three of these.
Files come up.
Yes.
Files come up.
Okay.
Yes.
Second.
Do we have any public comment on the motion?
So this is 9 minutes. I see 9 minutes. Yeah? Thank you. Peter Warfield, Executive Director of Library Users Association. We're not party to this, as I mentioned. First of all, I appreciate very much all of the questions that all of you have asked. I think that's extremely valuable, extremely useful, and that's the direction the task force, it's sort of back forward to the past, where the task force was very active in questioning folks on all sides and trying to get at, one might call it, the truth. As I said before, I think it would be very valuable for you to have the people who are named in the complaint appear personally, and I think, especially in the case of repeated problems, let them know that a failure to appear, and you set the consequence, but I think at a minimum you might warn them that that would incline you to weigh much more heavily the evidence that's being presented by the complainant, or even to doubt their story. And we've seen that before, where they send somebody quote-unquote knowledgeable, and it's hearsay, basically. The complainant has mentioned lies from Kate Patterson. The complainant has mentioned complaints from Kate Patterson about the extensive documents, quote, extensive documents, unquote, and basically complaining about what efforts she's got to do. She's also complained about what I would consider unprofessional provision of documents. So when you're having multiple installments of documents, it seems to me the very simplest level of professionalism that can be expected is, dear so-and-so, with respect to this request, this is installment number 2 of 4. You know, the files are too big. Or this is the second installment, and we will send you the rest by such and such a date. We're not necessarily sure how many installments will follow. We're still looking, whatever. So there's a whole range of complaints against what is a perfectly legitimate information request. And we've seen this from other kinds of things as well. We've seen Sue Blackman viciously attacking Ray Hartz for supposed alleged bad behavior, rather than just dealing with the requests. And I think in these matters, you need to put your foot down very sharply and let the responsible folks know that you don't buy it and you don't appreciate it. And if anything, that's probably an indication, certainly in my mind, that there's an argument ad hominem being made instead of the substance being dealt with. Let me back up a moment. If you look at the election handbook for the Sunshine Ordinance and its update in 1999, it's very clear that there was contemplated extra work and extra time being required for implementation. And the controller said a specific number. It was well into the six figures in the original passage of the Sunshine Ordinance. So the claim that, oh, we have so much work and it's overwhelming and it's too much and I have real work to do. No, the ordinance says that responding to requests for information is part of everybody's job. And the implementation originally, the ordinance itself acknowledged that there would be, the voter handbook acknowledged there would be time and effort. In my case, just as another example, there was Sue Blackman making a complicated case in which she asserted a legal explanation for something which was entirely misleading and intended to mislead you. Whether she got it from the city attorney or herself, I suspect the city attorney, but it was made in a highly misleading way. And I think you need to take some steps to let people know you don't appreciate that, and that that's a sign of bad faith, and that their argument is weak and doesn't hold water. So I support your going forward with this. I do think that over and over and over and over again, you need to put your foot down pretty quick and let them know that you're not going to tolerate this as just another complaint. I think it should be considered as a willful violation, considering the treatment that the complainant has gotten and the record of the Arts Commission of so many violations in the past. And I also think it would be very valuable to you and everybody if you would put your foot down about tricks that are used to either evade the issue or to dump on the complainant for making legal, perfectly legitimate information requests. Thanks.
Thank you. Mr. Clerk, can you call the roll, please?
On that motion, Member Barnetsky.
Aye.
Barnetsky, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. Next on the agenda, announcements, comments, questions, and future agenda items and pending calendar by members of the committee. Are there any announcements?
Were you here? I kept
Here, been
hearing
here the whole
lady, and I couldn't see. I don't know where that was coming from. Hi.
Hi. When you're ready. Oh, okay, you ready?
Yes,
okay,
yes, of course.
Great. So I'm speaking from the podium just to make it easy. So this is Bruce Wolf, the chair of the Sunshine Orders Task Force. So I have a couple of things I wanted, and I purposely sat in the back, very quiet. I wanted to observe, how things were going. I wanted to offer you some of my observations while I have all of you here, and I would, so hopefully I'll get to some of them. First of all, when doing combining of complaints, I would suggest, because we want to try to be consistent in case we want to do this at the full task force too. And since we don't have a rule on it yet, we haven't discussed this much at the rules committee yet, that you waive the rules. Make a motion to waive the rules for this particular purpose, and then create a process that's amicable, that seems reasonable to you in providing, how much time. So in this last case, it was 9 minutes. Do you want to offer 9 minutes for everything all the way through? Just so to be consistent, so that way every other time that it comes up, you have some idea what some kind of baseline for it. And if you waive the rules and you apply it specifically and only to this case, then you can make kind of ad hoc adjustments for each case if needed, until we get a rule that will lay down. It would also be helpful if the Complaints Committee tries to make a recommendation on its opinion if there is an actual violation. If there's not a violation, then say so. Say that would be somewhat of a recommendation, because I'm going to ask that the committee make the presentation of the case before it, because we want to make sure that the task force members understand what you have kind of pulled and culled together here. But nonetheless, at least provide a clear description and explanation in the motion for recommending it to the full task force that would help facilitate the task force understand the elements of the case. So that way it could be included in the agenda. And so that way, if they happen to read the agenda, they could be a little more prepared and know that you three understand exactly what's going on, and that they would also have that level of understanding too. I'm going to take the liberty as chair to just continue speaking. Agenda descriptions shall, I think agenda descriptions should stay the same, the way they are, okay? And the reason why is because in the past, when interpretations of what the agenda item is put in there, sometimes we don't understand the details yet. And coming to the complaint committee, it's the purpose of it. So get all the details out, make sure all parties, if they're here, are clear about what and that you guys are clear with that the complainant has presented it as what their complaint says. Sometimes the complaint is not very clear, so you're here to kind of figure that out for the rest of us. And I think, yeah, that's about it. So I just wanted to kind of point out those observations, and hopefully it'll be helpful.
Thank you.
Mm-hmm.
Is there any other public comment on this matter?
Peter Warfield, Executive Director of Library Users Association. I'm assuming that since you gave the previous speaker extra time, you're going to give me the same amount of time.
No, he took the liberty as chair. I wouldn't have given him.
Well, he's public comment in this meeting. So
you'll receive 3 minutes.
Okay. Well, I don't think that's appropriate or legal.
I hear your complaint. Thank you.
So, and he doesn't have special authority as chair. He's a member of the public.
Thank you.
For saying that, I think the chair is in front of me, not behind me, but saying that, I'd certainly agree with much of what he says. I think that your job to clarify issues and so on and so forth would be, could be done to a greater degree. What I would like to see is very clearly having the task force have a clear sense of what the claims are or the charge, and what would the order of determination say if everything that the complainant says is true and the defenses of the respondent are not adequate, and so on. I have found it very problematic that the task force so often basically seems to fly by the seat of its pants when it makes orders, and sometimes omits completely, or seems to omit completely, any consideration of what's been requested to find a violation of. I do think that combining cases is very, very, very problematic, especially at the last minute. But I do agree with the previous speaker that you should be very clear about the rules, including how much time, for example, for public comment. What I was going to start out saying prior to the Chair speaking, is that everything that I said in the previous comment, and by the way, I did not take the full 9 minutes. I think I took about 5 and change. The issues that I raised, I think, need to be considered as part of your procedures, informally or formally. I do think that when you're getting attacks on complainants from the respondents or misleading statements or even lies, I think you should take note of that. It shouldn't be that there's no accountability for abuse of complainants by respondents or misleading you with arguments that are clearly nonsensical or false. And I think that that should be something that you express an opinion on, not just sticking to the complaint. And that should be on a future agenda for yourselves and for the full task force.
Thank you.
Thank you.
Do you have any other comments for this evening?
Next on the agenda is adjournment.
We have a motion for adjournment.
So moved.
Do we have a second?
Second.
Thank you. This meeting's adjourned. Meeting's adjourned.